Welcome to Civics in a Year, the podcast that makes civic literacy fast, accessible, and surprisingly engaging. In just 10 minutes an episode, we'll tackle one of 250 essential questions about American democracy, how it works, why it matters, and what it means for you. Whether you're a student, a teacher, or just someone who wants to better understand your country and your rights, you're in the right place. Civics in a Year is powered by the Civic Literacy Curriculum from the Center for American Civics and is produced in partnership with the School of Civic and Economic Thought and Leadership at Arizona State University. Welcome back, everyone. Today we're talking again to Dr. Bienberg about, I think, a very misunderstood amendment. Dr. Bienberg, the Ninth Amendment says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. What does this mean?
Yeah, this is one that I think is easy to lose track of what it's doing. So what it formally means, and again, remember, the Ninth Amendment is originally binding on the federal government. And that matters because at the time of the founding and for most of American history, the Ninth Amendment was thought of as effectively a pair with the 10th. So it's a federalism provision, not an individual rights provision, is how it was traditionally thought of. So what does that mean sort of in a little less abstract terms? Well, the Bill of Rights, as we've talked about in the earlier parts of the podcast the last couple of weeks, is a set of basically guarantees of individual rights. And many of the critics of the Constitution, as we talked about, had said, we want a Bill of Rights. And the defenders of the Constitution said, well, the problem is that a Bill of Rights makes sense for your state governments because your state governments are assumed to have all authority unless you've told them no. But the argument went, particularly advocated by James Wilson and we'll talk more about James Wilson in a future session. But James Wilson is the first to really push this argument, and then it gets picked up probably more famously by Alexander Hamilton in Federalist 84. And they argue, in a system in which the federal government only has limited and enumerated powers, we don't even need to write this in here because we've never given them, for example, a right to regulate freedom of speech, a right to quarter soldiers or something like an explicit power, the federal government. And the critics of this argument effectively say, yeah, but you wrote in that there shouldn't be bills of attainder. There's a couple of things that seemingly are prohibited anyway. But more broadly, obviously, there's going to be a commerce power, which means that you get to regulate smuggling. And if you're going to do smuggling, you get to have trials. Do your trials have to be by jury? Right. So effectively, they asked for the kinds of guarantees where the federal government seemingly would have an enumerated power hook. Right? Congress has the authority to declare war. Well, does that mean that you can regulate speech during wartime? So, does the necessary and proper clause implementing these powers mean that the government could, in fact, trample on these rights? And so the Ninth Amendment is designed to deal with a very specific problem, which is the Federalist 84 James Wilson argument of if we say that Congress or the president can't do X, Y, and Z, does that invert the sort of whole logic of federalism and say that now that the federal government can do anything that you didn't specifically ban it, right? Does this now mean that Congress could regulate stuff unless you told it no? So it's dealing with this very, very narrow problem. And unfortunately, this is one of the places where Congress, when they're sort of trying to stylistically create the Bill of Rights, I think messed it up because the ratifying conventions, and we'll talk about this when we look at the 10th Amendment in a second, and in this next in the next couple of podcasts. The ratifying conventions requested particular amendments, and James Madison collected them, and then sort of tweaked them, collected them, redrafted them. And his explanation or his draft language of the Ninth Amendment, I think, makes a lot clearer what it's supposed to be doing. So he says, again, this is his draft. Congress then tries to compress it, but they compress it so much it becomes opaque. The exceptions here or elsewhere in the Constitution made in favor of particular rights shall not be construed as to diminish the just importance of other rights retained by the people or as to enlarge the powers delegated by the Constitution, but either as actual limitations of such powers or as inserted merely for greater caution. So again, that's too long, but Congress, basically what Madison's trying to say is just because we've written some rights that apply against the federal government doesn't undermine this idea that the federal government is one of fundamentally limited federal powers. And so we're going to write this in here just to say, no, nobody in Congress, nobody in a court can say, well, you didn't say we couldn't do it, so now we can. Right. So it's a rule of construction. It's effectively a rule most fundamentally to courts to say just because we wrote out a right doesn't mean Congress can do anything else. So that I think is pretty straightforward. The wrinkle comes if you are applying, and this will be another section we'll talk about, if you are applying the Bill of Rights to the states, because the states have the opposite assumption. Again, they can do whatever they want unless you told them no. If you think that the Ninth Amendment is basically just a federalism provision and it doesn't incorporate against the states, which is how most of the folks talking about incorporation originally said, then this is clean. This doesn't cause a problem. It's just a rule of talking about federal power. But if it applies to the states, you now are presented with a real complication. Now we have effectively a set of rights that are background assumptions that need to be applied against the states, despite their general presumption of authority. And that's where it gets really thorny. And this is why, generally speaking, most scholars and most justices on the Supreme Court take the position that the Ninth Amendment is not a construction, is not an application against the states. Hugo Black, so Justice Arthur Goldberg sort of floats it as an aside, as a possible justification and trying to say why states shouldn't be able to regulate abortion. So he says, look, the Ninth Amendment seemingly is another source of rights. And Hugo Black, I think, correctly says, having federal judges interpret and apply the Ninth Amendment against states seemingly inverts the whole purpose of it, which had been to basically keep the federal government constrained. And if now federal judges are saying, well, we didn't write this into the Bill of Rights, but we're going to discern some other sort of right, and we're going to apply it against the states, and this causes some real complications of federalism. So again, there are some folks that have made the case that the Ninth Amendment should apply to the states. I think it's fair to say that's a minority position. It's not one that a majority of the court has ever taken, but the Ninth Amendment really didn't have that much scholarship on it for a long time. Robert Bork, whatever one thinks of him in other ways, got a lot of grief for saying the Ninth Amendment is an inkblot, by which he meant, look, I'm a law professor. We haven't talked about that. I have no idea what it means because no law review article told me about it. But it was a defensible position because there just hadn't been that much scholarship about it, because it was generally recognized to be dealing with a very specific problem, which is James Wilson, Alexander Hamilton said, if you write out a Bill of Rights, you'll hollow out the enumerated powers. And the Ninth Amendment, therefore, is just nope, we still have fundamentally limited enumerated powers, even if we wrote a few out. So it's basically saying this creates a redundant check, reinforcing the idea of a limited federal government. So that's sort of what it's supposed to do. It's unfortunate that the language, sort of just as a straight read, doesn't. The language isn't clear without the historical context. If you have the historical context, the Ninth Amendment is pretty clear. It's what it's supposed to be doing is pretty clear. But without that, it's hard. So it's unfortunate that the drafters didn't sort of split the difference between the final text and James Madison, and just to say, something along the lines of, just because we've written rights doesn't enlarge the powers delegated by the Constitution to Congress. Like that phrase being left in there, I think would have made this a lot clearer. Sorry,
I was going to say, thank you for telling us about the original text, because I think that sometimes we get so caught in what we have now and what we're reading that this is the first time I've heard the original text. And when you read it, I was like, oh, well, that makes sense.
Yeah, it's actually quite clear. It's quite clear what it's supposed to do. Now, the one additional con law wrinkle is, bizarrely, a lot of states then wrote the Ninth Amendment into their own state constitution, which then opens up. I say that, right? It opens up all those problems of like, well, how do judges decide what other rights are these? This gets into all sorts of really complicated questions of constitutional interpretation. Is it other rights that were popular at the founding, other rights that seemingly are popular in history, other rights that sort of moral philosophers have articulated, natural law, some sort of religious tradition? Like, what do we decide include these other rights? Which, again, is part of why, as a practical reason, federal judges have said, like, nope, we're not touching that one. But some of the state courts have basically been forced into that. So, yeah, but that's not a problem of the Ninth Amendment. The Ninth Amendment is pretty clear what it's supposed to do. What those state constitutions are supposed to do, well, state Supreme Court justices, I wish you the best.
And you said at the beginning that this is a federalism provision so when we talk about the Ninth and 10th Amendment, 1 through 8 is a little bit different than 9 and 10, correct?
There's a little bit of a wrinkle about whether the Establishment Clause is also quasi-federalism because states still continue to have state churches. But pretty clearly by the time, certainly, of the mid-19th century, that argument falls away. So, yeah, 1 through 8 are clearly dealing with Congress, and then after application by the 14th Amendment, which will be its own podcast session, those apply to the states. But the 9th and 10th are closer to structural provisions, which is also part of why in Madison's original draft, they were not with the 1 through 8. They were going to be put into different parts of the Constitution. Madison wanted the Federal Bill of Rights or Federal Constitution amendments to be more like a state constitution, where generally you just tuck the text in there, in which case that would have made a lot more sense if it's listed after a description of federal powers. But that's not what Congress did. So that's why, without some historical context, the Ninth Amendment's really easy to squint at. And again, you can be sort of sympathetic to Robert Bork. Like, I have no idea what that means. But if you have some context and you have that earlier language, I do think it's pretty straightforward what it's supposed to do.
Fantastic, Dr. Weinberg. Thank you so much.
Thanks for joining us on another episode of Civics in a Year. If you enjoyed this episode, be sure to subscribe and share it with someone who cares about a constitutional republic as much as you do. For more episodes, resources, and updates, follow us on social media or visit us at civics.asu.edu. Make sure to check out the show notes for any relevant links. Special thanks to the United States Marine Band for their performance of the Stars and Stripes Forever. Let's keep building a stronger constitutional republic, one episode at a time.